Hello, this is Steve Rinka from the Rinka Law Firm. I'm here today to discuss how to respond to a complaint. Previously, I discussed how to serve a complaint on a defendant. Now, I'm going to be discussing what the defendant is to do once they receive a complaint. First thing you should never do is ignore the complaint. Ignoring the complaint is the worst thing that you can do. Once you've been served with the complaint, you must take action in order to preserve your rights, because if you don't take action to preserve your rights, you will get a default judgment against you in which you'll then have to fight to try and get vacated or dismissed, which can be very difficult, especially if you wait an extraneous amount of time. So once you are in receipt of the complaint, the first thing you should do in all likelihood is call an attorney to discuss how to appropriately respond. One of the ways to respond is to file what's called an answer. And in California State Court, an answer consists of a general denial, denying all the allegations and all the causes of action that are alleged against you, as well as setting forth all the defenses that you're going to use in order to defeat the lawsuit. And these can be defenses such as the statute of limitations, latches, other types of legalese type defenses that you'd want to consult an attorney with in order to know exactly what would be the appropriate defenses for your particular lawsuit. As you can imagine, depending on the nature of the lawsuit, there's going to be different types of defenses. Certain defenses in a personal injury action don't apply to defenses in a defamation or an employment action. So it's important that you discuss with an attorney what types of defenses are appropriate. Now, if you're served personally, you have 30 days to file your responsive pleading, as we call it, or your answer in this case. If you fail to respond within 30 days, then the plaintiff can file a request for entry of default. And what that does is that precludes you from filing an answer. And at this point, the plaintiff then just has to establish the amount of damages that they are allegedly owed to you, or money, in other words. And it's at this point that you would have to then fight against trying to get, one, the default vacated, and also trying to prove that the monetary damages the plaintiff is seeking is inappropriate. One of the other actions you can take when it comes to responding to a complaint is filing what's called a demur. A demur is a motion which you file with the court, and you're telling the court, hey, the allegations set forth in this complaint fail to establish a cause of action against the defendant. This basis for a demur can be that, one, the facts don't allege that I did anything wrong based on California law. Another basis would be the statute of limitations has run. The injury occurred 2 years and 1 month, and a personal injury action must be filed within 2 years. So all of a sudden now, this cause of action is vacated or barred by the statute of limitations. There are other grounds upon which to bring a demur. So it's important that you speak to an attorney who can address these issues to see if there is a basis to try and get the complaint dismissed. Also, you can bring what's called a motion to strike. And what this does is it seeks to strike certain portions of the complaint, or language in the complaint, I should say. So, for instance, if somebody's seeking punitive damages, you can ask the court to strike the request for punitive damages from the complaint. What this does is it prevents the plaintiff from actually obtaining punitive damages against you. You may ask, well, on what grounds could I seek to strike punitive damages? Well, if someone is just seeking a negligence cause of action against you, you cannot get punitive damages for a negligence cause of action. Punitive damages are only permissible where there is an intentional act to defraud somebody, assault somebody. There are only certain causes of action in which punitive damages are allowed. And then there's also other motions you can bring, such as an anti-slat motion, which is a very complicated type motion, something that only an attorney would understand in all likelihood, not to be arrogant, but that's just the nature of the beast. But that also can get the complaint dismissed right at the onset of the lawsuit. One other thing I should mention is you want to see who the judge is, because under California court system, you can strike a judge within 15 days of appearing in the case. What you have to do is file what's called a 170.6 motion, which you file with the court, and if it's granted, which unless you make a typographical error would be granted, and you would be assigned to a new judge. This can be helpful depending on the judge. Some judges are more versed in certain areas of law, so if your attorney knows this judge and thinks that this judge may not be the best judge to hear your case, you may want to have a new judge assigned to your case. Again, you want to go and seek legal advice as soon as you're served, because you only have very short timelines that you're dealing with upon service of the complaint. So it's very important that you act expeditiously. If you do have a complaint that you've been served with and you do need to consult with somebody, you can contact me, Steve Rinka, at the Rinka Law Firm at 310-556-9653. Thank you and have a good day.